The prized and championed $220 million ballot initiative in California known as Prop 22 came to a screeching halt yesterday when a judge declared it unconstitutional and unable to be enforced. Hey everyone, my name is Chris and welcome to the Rideshare Guy. And yes, California's giant ride-hailing delivery companies suffered a setback Friday as a state superior court judge invalidated a 2020 ballot proposition that allowed Uber, Lyft, DoorDash, Instacart, and other app-based businesses to classify their workers as independent contractors. Now, this was a lawsuit that was brought by the Service Employees International Union and several drivers. Alameda County Superior Court Judge Frank Roche ruled that Prop 22 is unconstitutional and unenforceable. All right, so what Roche said is that it infringes on the power of the legislator explicitly granted by the state constitution to regulate compensation for workers' injuries. And he states, if the people wish to use their initiative power to restrict or qualify a plenary or unlimited power granted to the legislator, they must first do so by initiative constitutional amendment, not by initiative statute. So that means that you need to use an amendment to the Constitution in order to be able to restrict some power that was written in the Constitution. Quick side note, I am not a lawyer. I don't speak legal jargon. I am not a judge. I don't know any of that. I'm just going on what the articles and what my comprehension is when it comes to what these things mean and what it could mean for drivers in California as well as other gig workers. And then also going on, it's saying by including language aimed at preventing drivers from unionizing, the ballot measure also violates the constitutional provision that requires laws and initiatives to be limited to a single subject. So Prop 22 claims to protect Californians who choose to work as independent contractors, but it also obliquely and indirectly prevents them from bargaining collectively. And that prohibition appears only to protect the economic interests of the network companies in having a divided, ununionized workforce, which is not a stated goal of the legislation. Now, here is a unique thing. I don't know if this is just California or if this is something that is across the US. Again, I'm not a lawyer and I don't create laws in any way, so I'm not technically sure on this, but it still is pretty interesting. And it goes on and says, since a ballot initiative cannot be amended after it is passed by voters, any unconstitutional provision renders it unenforceable. Now, Uber already came out and said that they are vowing to appeal. You know, all these other companies are going to hop on board as well and put an appeal in. And it says this ruling ignores the will of the overwhelming majority of California voters and defies both logic and the law, said spokesperson Noah Edwardson. We will appeal and we expect to win. So now, where is it going to go after it's appealed? Well, it's probably going to be heard in the appeals court, and then ultimately it will probably make its way to the California Supreme Court and ultimately have the decision there, whether Prop 22 is legal and enforceable or if it's unconstitutional. And this could probably add another year or even more when it comes to the final decision, whether it's going to be one or the other. So what does this actually mean for the California gig worker? Well, probably nothing is going to really change in the short term. Over the long term, things could potentially change or they could stay the same. It's going to depend on how the court goes from there. The only thing that I question, and this is me specifically, this doesn't mean anything else, so just take it as speculation, is Uber and Lyft and these other companies going to follow through on Prop 22's provisions, meaning the minimum floor earnings guarantee, the healthcare stipend, and a few of those things that are going to eat in their profits? For the time being, do they have to follow that? Because technically it's unconstitutional and unenforceable until proved otherwise. So could the next few weeks, months, year, while it's trying to be decided in courts, could they kind of sly away from it and be sneaky? And all of a sudden, well, it's unenforceable. We can't really do anything. Our hands are tied, and pull some crap like that? Possible. I don't think things are going to change too much when it comes to this ruling because they are going to try to appeal it. They want to make sure Prop 22 is in place. and then they can use it for going to other states like Massachusetts. All right, and now I want to hear what you have to say. Do you think it's a good decision? Do you think it's a bad decision? Do you think this is just part of the process on solidifying Prop 22 in the state of California and possibly other parts of the country? What do you think? Comment below, let us know. And make sure to subscribe and ring the bell for notifications, because if there's any updates that come from this, we will make an update video. If there are any changes that Uber and Lyft or these other companies try to do during this time frame, we will let you know. And it's not just the state of California anymore, because other states are looking at a possible ballot initiative or a possible law that's going to be very similar to Prop 22. So they might be looking at the challenges, again, that California is facing when it comes to trying to enforce Prop 22 or trying to overturn it. All right, everyone, drive safe.